I'd like to also welcome a past Keeble Lecturer, that's Malcolm Middleton, who gave a riveting urban design talk to planners. And I must say, in part, we did change some of the ways that we did operate. So thanks, Malcolm. And hopefully tonight, Ian can push us in certain directions as well. I'd also like to welcome an overseas guest who is clocking in. That's Peter Hyland, and from Singapore. So this is not just local. I'd also like to welcome Paul Lucas, the Honourable Paul Lucas, who was Deputy Premier and Minister for Planning and lots of other things, Paul, that I don't remember. Now, this is a free public lecture in recognition of the founding Professor of Planning at the University of Queensland, Lewis Keeble. Now, Lewis Keeble had the real distinction of being President of the United Kingdom Royal Town Planning Institute, as well as later on President of the Royal Australian Planning Institute, which is now the Planning Institute of Australia. His signature book that we had to read inside out, because he was my lecturer and Chris Buckley's lecturer and a lot of others lecturers at the time of the older folk online, was Principles and Practice of Town and Country Planning. Now, he had another distinction, Lewis Keeble. He didn't mind who he attacked for the trying to push planning where it should be in the psyche, because in the early 70s and late 70s, as you know, we had a Premier of this state who didn't think too much about planners or the sort of work that planners did. And he had the rare distinction, actually, of being attacked in the 1 week by the Premier of the state and by the Lord Mayor, who was Labor at the time. And now it's probably a good segue to move on to our lecture for tonight, Ian Walker. Now, Ian had a different approach to planning and to property and planning law. He preferred to sit down and talk to them. And half the time he used to talk people around, and which was the magic of working with Ian Walker, as a number of us who are listening in tonight have done. Now, Ian chaired the Ministerial Advisory Committee on changes to the heritage legislation, and that came to fruition in 2007, bearing in mind appointed by the Labor government of its day. He then, under Campbell Newman, became the first Assistant Minister for Planning Reform. And if my memory serves me correctly, responsible for both SARA and certainly the single state planning policy. And he really had worked on his previous property law background. He knew a lot of people. The way that he operated, as I mentioned before, was one more of a collegiate atmosphere. However, if he had to punch, he did. So that's probably the best little segue. I can now hand over to Ian to take you from here.
Well, thanks very much, John, and welcome everybody, particularly Paul, who I can see on my screen, and Peter Hyland, who's from very distant parts. Great to hear that you're both online tonight. Neville Chamberlain began his broadcast to the British people announcing that they were at war with the famous line, "I am speaking to you from the Cabinet Room at 10 Downing Street." Well, I'm much closer to you than that, but the delivery of this lecture via Zoom rather than in person, and without the associated bonhomie of the professional togetherness, feels a bit otherworldly, as if I were on the far side of the globe speaking to an invisible audience. It's impossible to read body language, to assess reactions, or to tell if my jokes hit the mark. But anyway, here we go in any case. The lecture is, of course, being delivered in the middle of a pandemic. COVID-19 has changed the way in which we view the world, our local communities, and ourselves. For you, Queensland's planning professionals, you face a whole new suite of problems and opportunities sent your way by COVID. I already see articles with titles such as 4 predictions for urban planning post-coronavirus, 3 design lessons for the post-pandemic city, COVID-19, rethinking urban planning strategies, and density can work post-COVID-19 with urban planning. Now, I'm of course no planner, and I'm certainly no futurist. So you'll be pleased to know that I'm not going to try my luck with predictions for the new COVID normal in a planning sense post this pandemic. But I did wonder how Professor Lewis Bingham Keeble would have reacted to our current circumstances. He was born in London on New Year's Day 1915, which means he would have been 3 or 4 years old when the Spanish flu struck Great Britain. He grew to become, as his successor as head of the Department of Regional and Town Planning at UQ, Phil Day, would record, an incredibly dedicated teacher, an old-style Fabian socialist, a military cross winner wounded in Normandy, a genuine libertarian and humanist, a scholar with an extraordinary store of classical allusions, and a fascinating conversationalist and stimulating companion. One thing I know for sure from my own experience is that Lewis Keeble would not have been silent while the pandemic swirled around him. He was at the height of his influence in Queensland in the late 60s and early 70s. After arriving with his wife Betty, who was also a town planner, in 1968, he conducted a course in urban studies within the Department of Architecture at UQ. He then became the founding head of the Department of Regional and Town Planning in 1971. These were my early high school years. I had no particular interest in or any family connection with town planning at that time, but I knew of Lewis Keeble, and most people interested in current events and the political and social goings-on of the time would have been well aware of his presence. Assisted in those days by what we now regard as primitive communication tools like talkback radio, he had the uncanny ability of making urban planning a topic of interest and debate among the broader population. The expert was interfacing with the masses, and I've gone a bit Fabian myself there, but that's a professional relationship that I'll come back to later in my address. Lewis was variously a leader in the profession, having been president of this very institute, a contributor to the planning of our national capital, a teacher who maintained an open house policy at all hours, a textbook author, a rager against university authorities, which he called the Kremlin, and an outspoken member of numerous committees and boards, often fortified in his comments by a handy flagon of rough red. He made his mark here before he returned with his wife to England in 1979 and established a planning consultancy there. He died in Oxford in 1994. It's right that we honour and remember him each time this annual lecture is delivered. Remembering our heroes, of course, puts the raison d'etre of the planning profession into some historical perspective. Town and country planning, as it was then somewhat quaintly known, arrived in Australia, like Keeble himself, from what was, for the most part of the 20th century, affectionately called the mother country. The UK took the lead, but acceptance of the concepts of this discipline in Australia was never guaranteed. As late as 1940, the Sunday Mail reprinted this excerpt from a volume entitled Town Planning with Common Sense. The article was headed, Town Planning Armies Advance. And I quote, "Nothing great or lasting is ever achieved except through hard battle. The enemies of town planning are many and welcome. There are already some of them rearing themselves above the trenches of self-interest. The landowner who sees in the movement an end to his nefarious schemes of subdividing his suburban lands into dog kennel allotments. The slum owner who discerns the early eradication of the hovels from which he can gather rent charges from multiple tenants. The professional man who, balked of the chance of using the movement for selfish ends, sneers at an association of architects, builders and engineers who find more soul satisfaction in designing to improve living conditions, who see the temples of God more in living flesh than in temples of stone and steel. There are would-be social butterflies who, foiled in the attempt to use the movement for self-advertisement or keep it confined to fashionable afternoon tea talk, sneer at their sisters and at their work that aims to lift the widow from the eternal wash tub, that gives the child a better place to play in than the crowded street or darksome lane, that gives the babe a fighting chance for life, that floods the lives of fellow beings with the maximum of sunshine, pure air and natural happiness. Such enemies are the snipers in the town planning movement today, but they are trifles compared with the main army of vested interests that will be met in the advance. And that's the end of the quote. So it's quite an emotional call to arms. I am pleased to say, I must say, that as a result of this article, all dog kennel subdivisions are presently impact accessible applications. It seems, however, that the image of the planner as a crusader for good didn't really ignite the touch paper that some thought it might. In 2014, Tom Campbell published an article in The Guardian, which had this rather alarming byline, and again I quote, "While the cult of the star architect has soared in recent decades, the figure of the town planner has arguably become common shorthand for a faceless dullard." Now, I don't wish, of course, to insult my audience. Campbell was, of course, referencing the UK experience. Clearly that wouldn't resonate, that description wouldn't resonate in Australia. Just look at the bow tie wearing and bicycling Brannock who introduced me today, an immediate rebuttal of the very idea. Campbell argues that, and again I quote, "It is not British cities that are in crisis so much as its planning system and planners. Just as they are needed more than ever, the status of planners and city administrators has never been lower." He goes on to say that in an age in which business is championed and the entrepreneur venerated, it sometimes seems that there are few professions more shameful than the local town planner. And politicians had provided grist to Campbell's mill. In 2012, then Prime Minister David Cameron announced a series of reforms intended to boost growth in the country. He came out swinging. The government was, he said, determined to cut through the bureaucracy that holds us back. And that starts with getting the planners off our back. I interpose to say that while preparing this lecture, I told one of my friends that I had the honour of presenting an important annual lecture to town planners. Planners, he said, aren't they the ones who want to regulate everything? That was his succinct reply. So perhaps David Cameron's comments were informed by some pretty accurate sounding of community sentiment. Going back to Campbell's article, he made the point that the education and training of planners in the United Kingdom was, in his view, somewhat wanting, and that the large and exciting areas of policy discussion within the SMART set was in the broader areas of economics, urban studies and culture. He wrote a novel called The Planner to further his argument. It explores the conflicting values and ambitions of those working to improve our cities. It might be worth a read. I should say at this point that I certainly don't accept the description of our planners as faceless dullards. But I think Campbell's article, set against Lewis Keeble's career and principles and that rather alarming Sunday Mail manifesto, sets us thinking about the role of the planner, specifically in contributing to good, effective public policy. Peter's own website states that planners are at the centre of complex debates about the places in which we live. Tonight, I want to amplify two words from that straightforward and unexceptional statement. The first is debates. How do experts, and planners in particular, take part most effectively in policy debate and eventually good policy formulation? The second is complex. What is the planner's responsibility to make the complex simpler and more accessible? I've had the rare privilege of being a practitioner in the private planning field, albeit at the litigious end of that game, a contributor to or an agitator for policy development, the secretary of the UDIA and chair of a number of law society committees, and then actually putting policy into practice as the first person, as John said, to hold the planning reform portfolio within government. So I've seen the process from pretty much all sides. And it's important to me to ensure that planners understand properly how influential they can be and how best they can wield that influence practically in the real world of policy making. And I've also seen the best of our planning profession, contributing through professional bodies like PIA to the broad debate, or giving sound advice internally to state and local governments. From that quite unique perspective, I want to examine tonight the role of the planner in two specific areas: as an expert in forming public policy development and as a potential simplifier of things in a world that is becoming increasingly complex. I want to do that with the minimum of theory and the maximum of worldly, practical, political hard-headedness. The role of the expert in public policy formulation has been thrust very much into public consciousness during the debate about COVID restrictions. I'm sure we've all heard the defensive cry, "I'm just following the health experts' advice," from politicians on all sides of the fence. And is that a surprise? As Ian Leslie put it in a recent April article in the New Statesman, would you rather our response to this pandemic was led by politicians or experts? I suspect most of you would plump for the latter. The terms have contrasting connotations. Politicians are self-seeking, deceitful, and full of bluster. Experts are disinterested, honest, and authoritative. It's tempting to punt the big decisions to them. But is that the right approach? When does reliance by a politician on the expert in whatever field become an outsourcing of the very decision-making the politician was elected to effect? Or, to put it the other way around, should the expert be the determinant of policy, or simply part of a process in which the expert plays a special but not a conclusive part? Let me go to my own experience, and for the moment I'll move away from the areas of either health or planning. This example takes aim at my own legal profession. Many submissions that came to Cabinet when I was a member involved legal matters, and frequently comment on new measures was sought and provided by the Queensland Law Society or the Bar Association. In all cases, the advice was well researched, it was clear, it was relevant, and it was helpful. I can't think of too many cases, however, where, quite coincidentally I'm sure, the advice received was contrary to the interest of lawyers. I point this out without implying that there was any overt attempt to promote the interest of lawyers in an underhand or unfair manner. It simply shows that those who have an expertise in a particular area are likely to value their expertise highly and perhaps overvalue it in circumstances where a broad range of issues needs to be considered. Ask 100 lawyers if access to legal representation is a fundamental right, and you'll pretty much get a universal yes. But set this in a policy debate where you are looking for the need for minor legal disputes to be resolved quickly at minimal cost. Well, maybe that can be done without lawyers. The expert advice always needs to be contextualised. The proposition can be put pretty generally. Ask 100 climate scientists whether climate change is important and you'll have little disagreement. Ask 100 nurses if hospital care will be improved by a better carer-patient ratio, you won't have an argument. Developers want red tape cut, of course. Architects lobby to seek a greater role for the government architect. Surprise, surprise. I put that one in particularly for you, Malcolm. I hope you're listening. Let me say again that none of the examples that I set out are meant to show a lack of concern for the public interest or a promotion of a private sectional interest in its stead. These experts are giving their honest opinion. Rather, What it shows, I think, is that the public interest as seen by experts is unavoidably coloured by a strong commitment to the expertise which they profess. Now, of course, experts should not be disregarded. Rather, their advice should always be put into context by decision makers. Decision makers certainly shouldn't pass the buck to experts to avoid resolving a policy dilemma that they've been elected to resolve. Ian Leslie, who I previously quoted, concludes as follows in relation to health policy. Experts cannot decide to do in this crisis any more than the politicians can author scientific studies on it. So what's all this mean for planners? Well, I think it means that in policy development, your expertise is valued, highly valued, and you should insist on its being considered. But don't lose heart or rail against the system if you're listened to, but not agreed with. In short, the old politician's saying applies. Experts are there to be on tap, not on top. Now, it's tempting to think that even when the advice of experts is given due weight in the policy-making process, and that is not too much and not too little, the policymaker can always be sure that the advice coming to her or him via the expert is good, hard, solid and reliable, is a good, hard, solid and reliable contribution. We frequently hear politicians claim that they are adopting a position that is reliant on so-called evidence-based policy. I am sceptical about this claim, at least as far as it implies that the policy is based on some values-neutral proposition. I think that, quite frequently, politicians go looking for policy-based evidence. All experts come to the table with their own set of values. That doesn't make them any less of an expert, and in fact, that may do quite the opposite. So decision makers should not accept, and experts should not insist, that the advice given to the decision maker has a purity about it that trumps the decision maker's own worldview. The bias in the expert's view of the world can be manifest in the very topics chosen to be studied or not studied, the data sets presented or not presented to the decision maker, the issues addressed or not addressed. A wily decision maker will seek expert advice, but be alert to the often subtle philosophical approach that the expert has taken. The lesson to the planner: be as aware as you can of your own bias and don't try to shake it off, as it's an important part of your expert view of the world. But beware that your decision maker won't be blind to that fact either. And like all of us, he'll be aware that the expert may often be running a line. I suppose it's natural for politicians to think that the more advice you get, the better your decision will be. The illusion of such a position has been well critiqued in a paper by Dr. Scott Prasser to the Australian Institute of Criminology. The paper's title is interesting. Why is it so hard for research to inform the policy process and government decision making? Dr. Prasser is a well-credentialed academic with practical experience as a senior ministerial advisor. He points out that to make good policy, one should follow the following steps: set goals, consider and weigh values, check resources, assess and compare all options, choose the best option, implement that option, evaluate in due course. But Dr. Prasser is concerned from his experience, as I am from mine, that a politician's natural defence mechanism often leads them to think that more information feeding into the process is invariably better than less. Academic Carol Weiss has pointed out that there is a high symbolic value in requesting information and justifying decisions on information grounds. Academics Fellman and March go a bit further. They say this: the gathering of information provides a ritualistic assurance that appropriate attitudes about decision-making exist. Information is not simply a basis for action, it is a representation of competence. More information leads to better decisions, which engenders a belief that having information itself is good. An organisation with more information is better than an organisation with less. The temptation for the politician then is to gather more and more information, leading to more and more reports, then briefing upon briefing, and in the end, decision paralysis. I'm almost tempted to say that decision paralysis is worse than a bad decision. I recall being told, and Paul Lucas might know this better than I, that former Deputy Premier Terry McEnroth was held in high regard in this respect, that rather than leave his office knowing that he would, quote, look into it, you generally left with a yes or a no. Now that may not be perfect decision making, but it is effective decision making. So what's the lesson for the planner? If you are giving internal advice to ministers or mayors, make sure that the information gathering process is effective and to the point, but don't let comprehensiveness outweigh the need to make a decision and to get on with things. While this information inundation is underway, the politicians frequently having to deal with other internal factors. One of these is that experts are often not of one mind. And to make it more difficult, there's not a faultless expert you can go to resolve the difference between the experts. In the recent pandemic crisis, the different opinions held by experts was exacerbated by the shallowness of their expertise. Once again, from the New Statesman. And I quote, "The Governor of New York, Andrew Cuomo, has remarked that his scientific advisors preface every answer with, 'I don't know.' The scientists know little about how infectious COVID-19 is, why it kills some people and barely bothers others, whether it returns to those whom it's already visited, whether and how it will mutate, or the best way to treat it. They are desperately trying to work out the best way to handle it, but it's like navigating in a snowstorm where every instrument is faulty. That's why the soothing phase, guided by the science, means very little. When the problem is as new as this one, there is no such thing as the science, just a spread of informed opinions which often contradict each other." While the novelty of COVID makes the example more extreme than it might otherwise be, it's still true to say, in my experience, that expert advice rarely comes unanimously, unambiguously, and without the nagging doubt for the decision maker that there's another expert view out there just waiting to ambush you. So my tip for planners, don't overstate or oversell to put your expert view. Acknowledge there are other views, but argue yours to the fullest. Another critical distinction to be aware of, whether you are a planner seeking to influence policy from the outside or one working internally to advise government, is the difference between what some researchers call hot advice and what's called cold advice. Prasser puts it like this: bureaucrats and academic experts believe their role is to give cold, rational advice. They are not ignorant of the political context, but see their role to give advice that is factually based and long-term in focus. Hot advice is what drives ministers and their minders. It is meant to be an overlay to rational advice, and it serves a very legitimate role in a democracy. After all, democratic policy making is not just about implementing formula based on policy solutions, but about accommodating interests, building support, and developing policies that are acceptable and able to be implemented. However, the problem is that hot advice seems to be becoming more dominant, and the public service is increasingly expected to move more and more into the hot side of the advisory game, to think about the political consequences rather than to focus on developing rational policy proposals. Now, cold advice has the following characteristics. It's information-based, researched, independent and problem-solving, long-term, proactive and anticipatory, strategic and wide-ranging, idealistic, public interest-focused, has open processes, objective clarity, and seeks the best solution. Hot advice, on the other hand, relies on fragmented information or gossip, may be ideologically based, is partisan and about winning, is short-term, reactive, single issue, pragmatic, oriented towards electoral gain, may be secret or deal-based, may have ambiguous or overlapping goals, and is often a consensus solution. I know from my own experience that this tension between hot and cold advice is a very live decision in the issue in the Office of Ministers and with their advisors. It's not a problem to have both types of advice. In fact, I think it's helpful. But the hot variety shouldn't be allowed to swamp the cold variety. An instructive example comes from a friend of mine who was a senior advisor to two ministers some time ago, two ministers in the same portfolio who succeeded each other. The first would read the briefs, consider the arguments, have his own view tested, and then make a decision. The second would simply ask, what electorate was that in again? Shows the different contrasting approaches. What's the lesson for the planner wishing to influence policy? Don't compromise your own position, but if there are political pluses in what you propose, don't hesitate to emphasise them. I want to turn now to the issue of simplicity in legislation and in procedures. My favourite hope when I was a lawyer was that these words would fall from a politician's lips. We're going to simplify the legislation. It was on the back of these words that I think we bought our first investment property and saw our two children through high school. Politicians rarely succeed in simplifying legislation, and even if they do achieve that, the ensuing round of legal cases interpreting this simpler legislation is a great earner for lawyers. A century ago, even the bench recognised this, with United Kingdom Justice Asprey commenting in deciding a property case that this interesting question is considerably complicated by the simplifications introduced by the new property legislation. So what was meant to be simple had in fact become complex. It was one of the reasons that I had a different view from the majority within our team when the government of which I was a member came to review the provisions of the Sustainable Planning Act. My view was that we should identify the hotspots that were creating problems within that act and fix those. We should aim to leave the balance of the act intact. I was aiming for minimal change to create maximum benefit. That view didn't prevail. And you may recall that we decided to draft totally new planning bills, which we introduced to the 54th Parliament, but which lapsed after we lost government at the end of that parliamentary term. In the 55th Parliament, the subsequent Labor government introduced their own bills, which were substantially the same as our draft. I'll speak more about specific legislative reforms later. Suffice it to say that the feedback I receive on the Planning Act is that the best endeavours to simplify and make clear have not, unfortunately, been completely realised. Let's step back a little and look at legislation in its broadest sense across the years, a march towards inevitable expansion and complexity. There is an old story, apocryphal I expect, which sets the trend. It goes like this. In England, 100 years ago, when divorce in the modern sense was possible only by Act of Parliament, an unhappily married town clerk was promoting a waterworks bill for his town. And in clause 64, mingled with something technical about filter beds and stopcocks, appeared the innocent little phrase, and the town clerk's marriage is hereby dissolved. Nobody could explain how those words got there. And in fact, nobody ever noticed them while the bill was going through Parliament. For everyone was fast asleep long before they got to that clause. In due course, the royal assent was given and the town clerk lived happily ever after. At a ripe old age, still in harness, he died still in harness, and a successor had to be found. The question then arose whether this particular provision was personal to the deceased town clerk or whether unhappily married members of the local government service could take advantage of this provision for as long as it lasted. So in that case, complexity didn't only confuse those who had to work with the legislators themselves had been bedazzled. Planners might think that growth in complexity in planning legislation is unique to their own subject matter. That's not the case. When I was in law school in the mid-1970s, we studied the Residential Tenancies Act, 1975. It had 35 sections and it ran for 14 pages. I remember taking the leaflet version of lectures in the back pocket of my jeans. It's legislation that sets out the rights of landlords and tenants in residential housing disputes. 19 years later, the Residential Tenancies Act 1994 had 355 sections and ran for 255 pages. It covered exactly the same subject matter. The 2008 version of the Act has stretched to 568 sections, over 372 pages, still covering the same subject matter. The Planning Act looks positively lightweight by comparison with its 354 sections. So that's residential tenancies. 1975, 35 sections, 1994, 355 sections, 2008, 568 sections. It is indicative, right across the board, of an unacceptable increase in complexity in legislative measures. Now, governments have tried everything to ensure that simple means simple. In government, we have a rule of thumb that required a minister to find an equivalent amount of legislation to repeal when you were introducing new legislation. The Abbott federal government introduced a legislation repeal day to concentrate on just that issue on a single parliamentary day. These are perhaps blunt and indiscriminate approaches, but they do concentrate the mind on the need to keep legislative volume at acceptable levels. The Office of the Queensland Parliamentary Council tries hard too. It requires drafters to use, and I'll quote, consistent plain English provisions that should be readily understood by the corporate world. However, it's equally important when drafting in plain English to avoid simplifying the legislation to the point where it becomes legally uncertain. Legislation should be as simple as possible and contain only the degree of complexity necessary to achieve desired policy objectives in a legally effective way. In balancing the requirements of simplicity and legal precision, the drafter must never be forced to sacrifice certainty for simplicity, since the result may be to frustrate the legislative intention. An unfortunate subject may be driven to litigation because the meaning of the act was obscure, which could, by the use of a few extra words, have been made plain. This, of course, lays out the tension for the drafter, and it's summed up in the standard instruction that as a solicitor, you frequently get from your client. Keep this simple, but make sure it covers everything. Former High Court Justice Robert French has set out the consequences which may flow from complexity in statute law, and these include their democratic legitimacy, the inaccessibility of the law to the ordinary reader, the ordinary run of non-specialist legal practitioner, and even perhaps a significant number of the legislators who voted for it may affect perceptions of its democratic legitimacy. Public confidence in the law, the difficulty of discerning the public purposes served by such laws reflects a want of moral clarity, and coupled with that, an acceptance that the law is just and reasonable. The certainty of the law. Complex laws carry their own difficulties in interpretation and associated difficulties in predicting how the law will be interpreted and applied by those concerned with its enforcement and by the courts. Transaction costs. The transaction costs of interpreting complex laws and advising upon those interpretations involves time and therefore cost on the part of non-specialist advisors, and perhaps less time but more cost expended on specialist advisors. Complexity gives rise to contestable interpretations, which may engender more disputes requiring dispute resolution mechanisms and ultimately a resolution by the courts. And importantly and finally, the growth of less visible soft law. Complex law administered by public authorities tends to require extensive written guidance to the officers of those authorities who have to administer the law. Those administrative guidelines may become, for all practical purposes, the real law, so far as many people are concerned. I don't need to tell any of you that planning law, and let's perhaps extend it to planning and environment law, has not escaped this expansive reach of the scourge of complexity. Some years ago, I delivered a paper at the IPA reunion conference in Longreach. Many of you would have been there. The topic was something like the weight of planning legislation. I thought the best way to make the point was to actually weigh the legislation and compare its evolution from my days at law school to the then present. The exact figures elude me, but I recall that I was talking in grams 40 years ago and kilograms today. I'd hesitate to do the exercise now. My lawyer son Luke has kindly provided me with a schedule of the legislation which presently exercises the interest of the Planning and Environment Court. It forms an annexure to my printed paper. It is a very extensive list, and it doesn't include relevant Commonwealth legislation. Now, those of us in the planning or political worlds or the legal profession are well aware of the complexity of planning legislation, and to a certain extent, I think we've become inoculated to it. In my time as a Member of Parliament, however, it became very clear to me that for the ordinary person in the street, modern planning schemes and modern planning concepts and processes are difficult, misunderstood, and often suspect. Many constituents found planning schemes incomprehensible. They believe performance-based planning failed to give them the certainty they wanted, and they were deeply suspicious of the genuineness of community consultation. While the overall trend in planning legislation has been towards the expansive and the complex, there have been some notable reforms which I believe have headed in the opposite direction. Please excuse me if I take the two examples John Brannock mentioned in the introduction, which occurred during the time I held the planning reform responsibility. I take some comfort from the fact that their effectiveness isn't just the view that I hold. Both reforms won national peer excellence awards. As I move to discuss my time in government, it is opportune to note the tremendous support we received from our staff inside the Department of State Development, Infrastructure and Planning, as it then was. Expert advice, well dispensed, was the order of the day, with our agenda progressed and enhanced by their efforts. Many of you will recall that following the 2012 election, I hosted a number of planning reform forums commencing in June of that year. All relevant stakeholders were involved, and I would count the forums a great success. The consultation was, I believe, genuine, focused, and relatively brief. The outcome formed the basis of the planning bills we eventually introduced to Parliament, but in the meantime resulted in some specific forms, two of which I will concentrate on now. The first was in relation to the state's contribution to the development assessment process. I was Assistant Minister to Deputy Premier Jeff Seeney in our first year of government. Jeff was a punchy politician in public, but a thoughtful and effective administrator of his department away from that public gaze. Most of us thought it odd that a considerable number of staff in our department were dedicated to resolving in an appeal context contradictory responses that had been given by various state entities acting as referral agencies. The forums mentioned earlier had highlighted the inefficiency of the state referral process. Our solution was to create a single assessment referral agency, SARA, which instead of resolving inconsistent state responses at the tail end of the decision-making process, dealt with them up front. This simple and, dare I say, elegant solution was an internal minefield. The giving away of power from individual ministers and departments to the planning minister was not going to be achieved without a significant fight. Jeff Seeney's persuasive skills and political clout were able to seal the deal, and SARA became a reality by way of amendments to the Sustainable Planning Act in September 2012, just 6 months into our term. My spies tell me that the prospect of individual departments bucking the SARA system is ever present, but it is, in my view, a reform that is here to stay. SARA won PIA's National Improving Planning Processes and Practices Award in 2014. Another area of criticism which came up during the forums I conducted early in our term of government was the confusing and complex nature of the suite of state planning policies which we inherited. There were 14 separate policies. The new policy which emerged from the consultation process arranged the 16 separate state interests under 5 broad themes: livable communities and housing, economic growth, environment and heritage, hazards and safety, and infrastructure. Queensland's new state planning policy was announced in November 2013 and won PIA's National Improving Planning Processes and Practices Award in 2015. In this frenzy of self-congratulation, I must note here, as I frequently noted to Jeff Seeney, that after I left the planning portfolio, he didn't win any further national PIA awards. So let me try to summarise the issues I've canvassed tonight. I trust they come from the principles I've discussed, as well as those practical examples of SARA and the single planning policy. Firstly, planners are experts in their field. They have an obligation in important public policy debates in which their expertise is relevant. Secondly, if you are contributing to a debate, either within government or without, remember that your expertise is but one factor that the relevant decision maker needs to take into account. There are always other factors in play. The decision maker has the responsibility of making the decision and facing the consequences. Thirdly, no expert advice is free of value-based factors. There is no neutral advice. Don't ditch your values, but acknowledge that they're there and own them where appropriate. Fourthly, don't overload on expert input to public policy decisions. There needs to be a brake on the information flow and an urgency about determining a position and actually getting a result on the ground. Fifthly, there is no single expert view. It's not possible for a decision maker to just follow the science. If you are one of a number of experts involved, acknowledge the different approaches and plainly state your case. Sixthly, your input and/or advice should clearly be of the cold and impartial type. But if there is a hot button to be pushed, don't be afraid to push it. Next, at all costs, keep things as simple as possible. And finally, in my view, attention to specific policy or legislative failings generally give better outcomes than wholesale legislative revolutions. So there is my prescription for the effective planning input into public policy decisions. I started with Chamberlain's speech to his people declaring war. He finished with, "I know that you will all play your part with calmness and courage." I know that the same applies to you all. Thanks very much.
A round of applause, by the way, Ian. Okay. Yeah. Fantastic. We knew you were going to be interesting and at the same time quite challenging. Thank you very much indeed. Now, before getting on to questions, and this is another part, not sure I did mention to you, part of the process with the Keeble Lecture, he may or may not have to justify the positions that he or she just took. But before we get on to that, I'd like to acknowledge Chris Buckley, who was also a Keeble lecturer and who gave some extremely wise, thoughtful backgrounds to his time in the profession, and he's still in the profession, one of those rare examples. He's a life fellow of the Planning Institute as well. And also to Wendy Evans, who is our state president and a lawyer, of course. And okay, you have thrown out, as I mentioned, a couple of challenges. And what we'd like to do is open it up to a few questions, not too many. We try not with normal audience participation with Keeble to have statements from interested parties. We try for the participants to ask questions themselves. So could those who are interested in asking questions, please go to your chat or raise your hand, and one way or other, we'll try to get through to you. Because I think there's going to be a few about complexity of legislation. We're always interested in how to bring that to a level where it is quite simple. And of course, the first people that we see as being in our way is lawyers who want to make it complex. But I won't ask the first question. Do we have, there's a chat here. Paul Lucas, yes. Paul did, no, he didn't. He sent me a private chat, I think, which is a very good question, really. But okay, we'll open up to others. It would be surprising if we didn't get one. But Ian, could you just take that comment of mine as a question? The complexity, as planners, we actually try to not dumb things down, but because we do talk to the public a lot, we try to make things simple. And when it goes through the whole legislative process, it seems to be 2, 3, 4 times longer. How do you respond to that?
Yeah, look, I think it's a fair point, John. I mean, lawyers used to be paid by the word. I suppose that's the starting point. We tended to be long-winded. And I'm not pretending that, simplicity is an easy end to achieve, because as those drafting, parliamentary draftsmen's comments showed, too simple and people lose rights or have to go to court to determine what was really meant. And so, simplicity is not an easy target to achieve. I think after I've sort of thought it through, John, I think, the real problem comes more with, I suppose, put it this way, as a politician, it's great to have your name on a huge reforming piece of legislation like IPA or the Sustainable Planning Act or the Planning Act, whatever it is. Whereas I think that, as I mentioned in my speech, I think you can achieve more and in fact, get more simple solutions by looking at particular problems. I felt, for example, under the Sustainable Planning Act, that you could probably list 10 problems with the Sustainable Planning Act that you could fix with 10 fairly simple amendments. I didn't think it needed a whole new planning act. So look, I don't think there's a magic wand as to how to do it. I think lawyers have got their part to play. I think lawyers are better than they used to be in terms of simple language. But in many ways, I think it's really the process we go through of not having to reinvent the world every 10 or 20 years. As unexciting as it is, I think step-by-step amendment of legislation, plugging holes, fixing things, in the end, causes less complexity and gets a better outcome.
Thanks, Ian. I do have a few questions in chat. The first one from Michelle McMahon. Ian, you achieved a lot as Assistant Minister for Planning Reform. It was joy to brief you. What are you most proud of?
That's an interesting question, Michelle. I think this is an ironic thing in the present political circumstances for my side. But probably what I'm most proud of in my whole parliamentary career was introducing the 4-year term legislation, which I think was supported by the other side and became a joint proposal. But I think that the referendum, which eventually approved that legislation, put Queensland on a fixed 4-year parliamentary terms, gave us a great basis for government decision making. I'm just disappointed that the other side have got the 4 years and not my side. That's life. So that probably was the most important thing I think I did. And oddly enough, I introduced that bill from opposition, not from government. So I think the most important and lasting thing I did was that. There hadn't been a referendum to change Queensland's constitution approved up to that point until 100 years earlier. And that was a referendum that allowed ministers of religion to go into state schools. So it was quite...
Yes.
So in the broad sense, 4-year terms I think was a big plus. I think in the planning area, I've mentioned already, but I think SPA was probably the single biggest reform that had the most immediate impact. And I think it not only had a process impact, but I think the process in itself caused departments and others to think differently about the state's contribution in the referral process. as I also said in my talk, I hear stories about some of the departments, the normal suspects I expect, are still throwing their weight around it and not always honouring the SARA process. But I think if I had to put my finger on, one planning reform, I think that was the most effective one.
I think one from good reform now, planning and environment legislation. What would that be?
Sorry, John, I didn't hear that, if that was the question.
Oh, yes. If I'll say that again, just in case it didn't come through. If there was one thing you could reform now in the current planning and environment legislation, what would it be?
Well, that's a good question. I suppose I should preface it by saying I'm no longer sort of a practitioner in the area, so I don't have day-to-day contact with it. I think, although it's a small issue, and I'm trying to think of the words. We only had a few issues in contention with the government when the bill actually went through. And one of them, and some of you online may remember what the particular terms were, but instead of the code and impact or whatever the current terms were, I think we were trying to look at terms that made it clearer to people as to what their rights were in relation to each of those sorts of descriptors, and whatever the descriptors are, I think it's hard to make it clear to people that things that are generally appropriate or code or at that end of the spectrum, are clearly regarded as appropriate or likely to be appropriate in the area, and at the impact end of the scale, I think the wording can sometimes cause people to believe that they've got to make a fuss about the proposal simply because of the terminology the Act uses. So I can't readily pull it out of my mind, but I recall that it was something at the time I felt strongly about, and I think either Pia or someone else had put up some alternate wording for those relevant provisions in the Act. But look, you've caught me a little bit on the blind side with that. I can't think at the moment. But as I said, I know that the problems I think that have come up, as I hear back from the profession and colleagues, are more to do with the precise drafting of the provisions than broad concepts themselves. So I think they're probably drafting issues rather than broad conceptual issues.
Sure. And this question, next question is from Julie Brooke. She says, hi, Ian. You said comprehensive decision making. How do we convince decision makers that knowledge is sometimes incremental? Decision makers are often very risk averse.
Yeah, look, I think that's true. I'm not quite sure whether knowledge being incremental fits into that, but I think decision makers are risk averse and getting more and more so. And I think, as I said in my speech, one of the ways I think that decision makers avoid things is, continuing to get reports and more information and more inquiry without actually, taking a deep breath and making the decision. Paul, I know, would have experience in this from his time, and I mentioned, Terry McEnroe, I think, was outstanding in his making decisions. I think, Julie, part of the answer is more to the fact that it's a bit like innovation. When I was the Science and Innovation Minister, the thing you had to get people to accept was that when you're moving forward in innovative areas, failing is acceptable. It's actually part of the process. You muck something up and then you go back and you fix it up quickly and you acknowledge the mistake. I suppose that broad principle, should apply in the policy making stroke political game as well. I suppose, the sad reality is that you don't get away with too many mistakes in politics that you can fix up without somebody making a pretty big fuss about them. And so I suppose it's that which is driving decision makers to be cautious. I think in many ways it goes down to the quality of the people who are offering themselves for political office, their experience, and their preparedness to take a punt and say, well, look, if I get this wrong, I can always go back and fix it up. But I think the premise to Julie's question, that there's too much backside protecting and little ability to take a deep breath and say, we're going to go with this, is a problem for the current decision-making system and the decision makers.
And Ian, I think Richard Hurl's next question, I think it's more like a comment. He asked, would like to ask Ian whether an expert presenting cold advice.
Sorry, John, I missed that, I think.
Richard Hurl asked whether rather than an expert presenting cold advice while stressing its political benefits, should that be a flush?
Should what?
Should it be referred to as a hot flush? I think there's a bit of a tongue-in-cheek thing.
That's right. I think Richard's probably thinking of a hot advisor presenting cold advice, but I don't know go there, really.
I think so. I think so. We have a question from Natalie Raymond. What do you believe would be the single most important action we can take as planners to begin to rebuild community trust in their profession, or to turn around negative community sentiment or attitudes towards their profession?
Yes, it's a difficult one. As I mentioned in the speech, I probably hadn't been quite as aware as I was when I was, sitting in the local office and people came to see me about planning issues. I shouldn't say that there's any venom directed to planners as a profession, but there's certainly confusion and disillusionment with schemes and processes. Some of those are hard ones to fix, Natalie. For example, community consultation. Now, my area covered Mount Gravatt, and Mount Gravatt is an obvious and sensible place to have density, given Garden City Shopping Centre, the bus station, the public transport, the main road and other thoroughfares that go through that area. And yet, that was a highly contentious issue for me. In lots of areas, ranging from the plumber parked the car on the footpath at 6 o'clock and I couldn't get out of my house, to the streets are blocked and I can't move, and so on. But one of the issues there, because I'd often talk about the fact there'd been community consultation, one of the issues there was, for example, in my electorate, that in between one election and the next, and that was a 3-year cycle at that time, 30% of my electoral roll had become new. So 30% of the people that were there for one election weren't there the election before. And so the 3 years prior to that, another 30%, and so on. You can see that there's a substantial turnover of people. So you might think you consulted with the community, but you consulted with the community 10 years ago, and the current mob really don't know anything about that consultation and haven't been switched into it at all. I think the question is, what can the profession do, I suppose, to change that? Again, I think, probably, Natalie, that the very things that I raised in the speech are the best ways to do it. Firstly, to insist upon your part in the process as professionals. But secondly, to do that in a way which doesn't demand or assume that planning professional advice has a particular mystical status, that it's got to be in the mix with all the other things that politicians are dealing with. And I think most planners get that. And then I think the second thing then is somehow we've got to move in all that we do to more simple procedures. And I know that that's, again, much more easily said than done. Performance-based planning, is a great example. As a theory, I think it's tremendous theory. It gives, in the end, the opportunity for better development than there would be if there were fixed rules and boxes to tick and invariable setbacks and so on. But I can tell you it's very difficult for a politician, sitting in their office when a well-intentioned, sensible person comes and says, look, I looked at the plan before I moved into the house. I saw that they could only go 3 stories next door, and now they've gone 5 stories. How can that be? Well, there's a good answer to that, but it's a hard answer to explain. So no magic bullet. Again, I just think professionalism combined with a commitment to simplicity, whatever that might mean, is what's going to get us there.
Ian, for fear of my voice sort of dropping in and out, I've been advised by the administrator. One further quick question she suggested. Do you think we should scrap performance-based planning schemes?
Well, that's a very big question. I mean, there are so many arguments for and against, that the arguments against, I suppose, are those perception arguments that I just went through. The arguments for are obviously that, within the development community particularly, there's a desire to say, well, look, what I'm offering for this site doesn't achieve what the prescription would do, but achieves a better result with a bit of give and take. It's easy, I suppose, to fall into the trap of saying, oh, the old days were better with prescriptive schemes, but we know they weren't. So in the end, no, I'm not a supporter of scrapping performance-based planning, but I think the explanation to the community has to be clearer, and an explanation of how the benefits of a development which has achieved the relaxation that performance-based planning allows is where the secret lies. So I wouldn't throw the baby out with the bathwater, but the bathwater's got to be cleaned up a bit.
Okay, well, thanks very much, Ian. We will close off there. But before we go, can I call on Matt Collins, our State Planning Manager, to say something to close out the Keeble Lecture?
Thanks very much, John. And on behalf of the Planning Institute of Australia, I'd like to sincerely thank Ian Walker for delivering this year's Keeble Lecture. Ian's contribution to planning in Queensland has been significant, first in his legal career and then in his parliamentary career. His enduring reforms, which we touched upon tonight, SARA and the SPP in particular, have enhanced our planning system and by extension, therefore, contributed to the creation of better communities. Ian's lecture tonight has given us all a significant insight into the realities of the public policy making process, and he has outlined how we as planners might better effectively exert influence. He's also talked about the limits of the expert and challenged us all to recognise that decision making is rarely values neutral. Often it's hot. He's issued a clarion call for all of us to resist the scourge of complexity. And his observations tonight, I think, are really timely because as governments increasingly focus on the economic recovery, it will be incumbent on our profession, I think, to articulate a positive vision for the future again, to demonstrate that we might still be the crusaders for good that Ian mentioned in his speech. Thank you, Ian, for your challenging and thoughtful lecture. Thank you, John Brannock, for chairing, and thank you to peer members and non-members for attending tonight's event. Thank you.
Thanks, everybody. Bye.